Testing, testing.
Hello?
What's up, Anita? You're live. I just want you to know that everybody can hear you. I'm trying to figure out how to get this thing off of my screen.
Oh, sorry. You were on mute for quite some time.
Oh, I heard.
Oh, okay, all right. Hi.
You resolved that issue.
Okay, cool.
All right. Well, luckily I didn't get that far into it. All I was saying was, happy Friday, first of all. Glad you all can join me on this crazy Friday afternoon. It's been a long day, but I'm here for this anyway. I was going to go over this Van Sham response. I'm already upset about it. Hey, Leanne's.
Yes.
What's up, Leanne?
Yeah.
You made it.
Here.
I'm joined by Anita and Leanne Newton. I'm going to address their questions maybe sooner rather than later because I don't want you all to be up too late on account of me. But I was going to go over this Van Sham. It's the response to the motion to compel. There's basically 6 requests for specific documents related to the Van Sham. There was objections to it. I've already went over it once. What happened? Oh, did we lose Anita? I'll tell you what I'm going to do. I'm going to mute you guys for now. I'm going to get through this letter, and then I'm going to come right back to you. And, okay.
Hello.
All right. We will deal with that. Let me get through this letter. So this is the response to the motion to compel. And it starts off, we write on behalf of non-party Van Zandt in response to the letter motion filed by defendant counterclaimant Jennifer Abel, seeking certain documents pursuant to a subpoena. The motion appears to be yet another attempt by Abel and the Wayfarer parties to use these legal proceedings to continue their negative media campaign against Blake Lively and her associates. This time by seeking documents from a third party that Abel already possesses or are irrelevant to any claims or counterclaims in this litigation. And, well, now that there's not really an existing lawsuit for Baldoni, that would be the closest to having any kind of merit towards anything. But if it speaks to some nefarious undertaking for evidence laundering, in other words, the argument being that they already had the evidence and they're trying to find ways how they get the evidence. There's this sham lawsuit that purports to involve parties that are involved in this case that may have given rise to other issues, whatever. They're allowed to make their inquiries is the point. And it doesn't matter if Abel already possesses them. They could get it from whoever they want for whatever reason they want. I know that Abel has them. I want to know what you have. In other words, I know what we have. Maybe we know what Abel has, but we want to get them from you. We want to see what you have. In other words, is it possible that there's 2 different versions of the same thing? Is it possible that you might have doctored the originals? You don't have to know my reasons, but I'm entitled to get them from you is the argument. Anita, I could see you. Leanne, I can see you. I'm just going to get through this letter and then I'm going to bring you guys back on just for time's sake. And then we'll deal with our audio issues then. This shouldn't take too long. So the only justification Abel offers is the Wayfarer party's time-worn argument that there was something improper with respect to the Doe lawsuit Van Zandt filed in New York State Court, which uncovered scathing evidence of Abel and the Wayfarer party's retaliation campaign against Miss Lively. But the judge's retort with that was, look, you guys are making these conclusory statements without giving me any evidence. If you guys have something to present, then fine. And so now they're in the process of making their inquiries to try to get answers to those questions. And so there's nothing improper about what they did. Of course, they got to have something to object to. This is it. I mean, I say that this motion to compel is going to be granted because it just feels like it should. What's the harm in proceeding with discovery? There doesn't seem to be a good argument against it. The argument that Jen Abel already has these documents is a weak one. The idea that it doesn't have anything to do with the issues that are relevant to this case is a weak one because you have wide range to discover things that you think may become relevant to the case. You might not know that they're going to be relevant. That's the point of discovery, but that's what they're going with. Abel offers no legal or factual support for this argument because there is none. What's more, Abel attempts to mislead the court by suggesting that two of the subsets of documents she requests, the subpoena issued by Van Zandt and the corresponding produced documents, are not fully in her possession when she knows they are. Again, that's irrelevant. They could very well fully be in her possession. That doesn't change the fact that they're allowed to ask for them from you. And that Van Zandt has somehow been uncooperative when in truth, Abel abandoned the meet and confer process and filed this motion out of the blue after no communications for 3 weeks. The motion should be denied for two principal reasons. Number one, Abel has already received the only potentially relevant documents, the underlying materials produced in response to the Doe subpoena, request numbers 10 and 11, and the remaining requests have zero relevancy to any claim or counterclaim in this litigation. There are no counterclaims. But they do have the entitlement to understand the origin of the evidence that formed the basis for their causes of action. That seems to me to be a relevant issue. If there's a suspicion that that evidence, even in the absence of a counterclaim, might have been nefariously obtained, then they have a right to make that argument. And they have stated that in pleadings. They've stated that in sworn declarations. It might have been removed off the record. It doesn't change the fact that they haven't put the judge on notice that this is what they were thinking before. And then the judge says, I can't do anything with this. I don't know what you want me to do. Bring me some evidence. So then they go and conduct discovery. This is basically discovery that the judge told them to do. The remaining requests of zero relevancy are moot, should be okay. However, as set forth below, to expedite this litigation and reduce the burden on the court caused by Abel's unnecessary motion practice and abandonment of the meet and confer process, Van Zandt will voluntarily agree to produce documents responsive to request numbers 10 and 11, even though Abel already has them. To request numbers 1 and 4, okay, based on Abel's narrowed request as articulated in the motion to the extent to describe below. Thus, the motion should be denied as moot as to request 1, 4, 10, and 11. Good. So there's nothing to say there. They're just talking a whole lot of shit. As to request number 9, which seeks communications between. By the way, chat, how does my mic sound? I'm hearing a buzz in my ear. Let me know if it's if you guys are picking up on it too, if it's just my headsets. Just a minor observation. All right, so what do they got to say about numbers 9? Number 9, which seeks communications between Van Zandt and or its counsel and Stephanie Jones and Jones Works and or their counsel concerning the Doe lawsuit. Abel should obtain those documents directly from Miss Jones or Jones Works before burdening third-party Van Zandt. If that's the extent of their argument, that's a bullshit argument. And this motion to compel is going to be granted as to request number 9. They have no obligation to rely on the documents they have from Stephanie Jones as an offer of proof, or Jen Abel for that matter. As an offer of proof, they could just simply state that, look, we think something nefarious happened. We know that we have versions of the documents. We want to get the versions that they have. And they don't even have to offer an explanation as to why. The explanation will be obvious. Maybe they're different. Maybe they're doctored. Maybe they don't have them at all. Maybe it was whatever. They have a right to request them from whoever they want. Where did I leave off? Abel should obtain the, okay. As an initial matter, the motion is notable for what Abel omits from it. Abel fails to inform the court that she abandoned the meet and confer process. Counsel for Abel and non-party Van Zandt conferred regarding. So just so you know, there's a rule before you file a motion to compel discovery, there's a rule that you have to meet and confer with the other party. So when they say they abandoned the meet and confer process, all that tells me is they did meet and confer, satisfying the rule. They weren't getting anywhere, and so they filed this motion. That's why you do it. They make the attorneys talk to each other and try to work it out before you bring this, and you have to file a declaration that we did meet and confer. And matter of fact, their motion did say that we try to talk, and we were continuously whittling down these issues and continue to whittle down the issues, and ultimately we reached an impasse over these 6 request. And no, so here we are. Here's our motion to compel. So this is a weak argument. During that conference and in a follow-up email, Van Zandt highlighted its various objections to the subpoena. Nevertheless, to resolve the dispute without the court's involvement, Van Zandt offered to produce 2 of the items that Abel now seeks, specifically the Doe subpoena served on Stephanie Jones in the New York litigation and the documents produced by Miss Jones in response. Then what are we doing here? If you offer to produce it, then what are we doing? Van Zandt confirmed this proposed solution via email on May 30th, 2025, and offered to further confer. Counsel for Van Zandt did not receive a response to this email, even though by that time, Abel had already received production of the subpoena and responsive documents over a week before this. So they do have the subpoena then. 3 weeks later, Abel filed the instant motion without any notice to Van Zandt, obscuring the fact that she had already had the documents in her possession. If that's true, that's kind of a relevant argument, but had they had the documents, had they already been, I don't know. Typically the whole point is you're trying to get your hands on the document. If they produce the documents, it wouldn't find its way in a motion to compel the documents. So fair play, if that's how it actually went down, that's just not what they said happened. They being the Wayfarer parties. Further, as a threshold issue, Abel's motion should be denied because Abel fails to demonstrate how the documents are relevant to the claims or counterclaims in this litigation. The burden of demonstrating relevance is on the party seeking discovery. Abel has a far-fetched theory that documents are relevant to her amended counterclaims. Abel's amended counterclaims, of course, are currently subject to pending motions to dismiss, which, if granted, would eliminate the issue in the issues in the motions entirely. But Abel's counterclaims are at heart an employment dispute with former employer Miss Jones and have nothing to do with Van Zandt. The claims arise from events Abel says occurred when she was terminated and her cell phone was obtained by her employer in August 2024. I keep forgetting that this is not the instant case. This is the Jones v. Abel thing. And so the counterclaims have not been dismissed. That was my fault. Even so, the fact that she could articulate what the relevance was, even if it's tangential to maybe the main elements of the case, it should still be granted. Got this last page. Moreover, the request also seeks documents that are more appropriately sought from Plaintiff Jones or other parties to the litigations. If documents are available from a party, it has been thought preferable to have them obtained pursuant to Rule 34, which governs discovery between parties, rather than subpoenaing them from a non-party witness pursuant to Rule 45. Yeah, but you do that all the time. You're allowed to get stuff from third parties. Like the best example I could come up with is I can ask the opposing party in a divorce case to give me their bank statements, or I could just subpoena them from the bank with the guarantee that they're not going to be doctored, which is usually the case. Like, it's not that hard to doctor bank statements. Like I get these bank statements from the opposing parties and they're all happy to give them to me. I was like, oh, great. I'll just subpoena these from the bank and just see if it's all on the up and up. And you'd be surprised how many times I caught people just because I subpoenaed the banks directly for records. How many times parties thought they could get away with just doctoring bank statements to make it look like they were making less income, for example. Anyway, there's reasons why you do that. Abel already received the Doe subpoena and documents from Lively and party to the related litigation with Abel, and any communications involving Miss Jones, to the extent they exist, should be obtained through her document request Abel has made to Miss Jones. Ultimately, the motion is consistent with Abel and her counsel's pattern of using the court's docket to advance public relations narrative in the media. I'm just getting so tired of this argument, man. Why don't you just sack up and grow a pair? If that were not their goal, Abel would have continued the meet and confer process, or at least responded. Oh, now this is getting silly. In addition to help resolve the dispute without further burdening the court, Van Zandt will produce its articles of incorporation. Good. And written consents of Van Zandt's board of directors, which reflect its officers and shareholders. Great. To satisfy request number 1 and 4, and for request number 9, any responsive communications with Ms. Jones' works, to the extent they exist, would be in the possession of Jones and Jones' works. This is so dumb. Just produce the frickin' thing. What are we doing? They're basically saying, no, we're not going to give it to you. They could get it from Abel. Kiss off with all of that. Okay. With that, my instant take is that I'm reluctant to, in this case, to start making predictions about what Judge Lyman is going to do. It seems like the easiest decision with this is they've made a tangential argument, offer of proof about why it's relevant. It doesn't matter that the other party thinks it's not as relevant as the other side, as long as there's some tie-in to the case at bar. The judge should compel the documents. It's not an argument to say that Abel already has this stuff, so get it from her. That's never a sufficient argument. So let me, without further ado, bring on Anita. Anita, how are you doing, young lady? She is muted.
Hello, I'm here.
There she is. What's up, young lady?
Good.
Let me bring on Leanne and cross my fingers and hope this works. How you doing, Leanne?
Hey, Roma.
Hey, you made it.
I did.
So we're all here. And so, all right. I just went over, obviously, the Van Zandt motion to compel opposition. My prediction, based on what I know as a lawyer, is that the judge is going to order Van Zandt to produce numbers 9 and 10. If he doesn't, I don't know what to say. But if he doesn't, it's going to be because he bought the argument that this isn't really relevant to any relevant issue in the instant lawsuits. But my take on it is that the judge should grant this motion to compel without much effort. And so we'll see. Now, you two, Leanne and Anita, have had a rough couple of weeks as the result of recent events in this litigation. You guys had a number of questions that you had for me. How are you guys feeling about this case? How's it going for you two?
Leanne, go ahead.
Thank you. I was surprised by the motion to dismiss.
Yeah.
Especially the decision around Ryan Reynolds. I thought they should have been allowed to replead that. I was initially shocked that they didn't refile the claims, but when I kind of sat on it, it did make some sense. But yeah, it's been a wild ride.
Yeah. So you had some questions about malice in this case, right? And your questions was essentially, how could the judge not find malice when it is so obvious that some of the assertions that Blake Lively has made are verifiably false? Is that pretty much?
I think that was Anita's question.
Oh, was that Anita's question?
Yeah. For me, it's the question is not necessarily just about the judge, right? So just in general, I'm trying to understand the law, right? Okay, I'm upgrading. I'm stepping outside of the space. So, from what I understood, in the pleading stage, you have to plead enough to get passed through, right?
Yes.
I'm just gonna give one example where they're talking like. They say that they have video proof of Blake Lively lying about the birthing scene where she said that she has a little nudity, something, what was it called?
Yeah.
The thing that's covering, and they say that they have video. If I were them, I would have just released that video, just, you know what I mean? But they didn't. I think that was going to be later on. They just released dancing video.
Yeah.
Just that one is right. So let's say we had gone past, we didn't. There's this thing I'm trying to understand. They said that, somebody might have lied, but is it malicious? What do you mean? Is it malicious? If you have lied about sexual harassment, how is that not malicious? I don't understand that.
I understand your question. The simplest way that I could put it is that there were no verifiable statements that Blake Lively made that could have been the subject of a defamation lawsuit. There were none. And the ones that she made were in her CRD complaint, which are privileged, which means they could not be the subject of a defamation lawsuit. That's where 47.1 comes in. I'll get to 47.1 later because I'm going to go over that, because Kassidy O'Connel made some arguments that I thought were really well thought out, and I wanted to give them fair play. But listen, the crux of the 12b6 motion was that there was not an identifiable statement made by Blake Lively outside of her CRD complaint that could be attributed to defamation. None. And if there wasn't any statements, what the judge basically said was, you can't prove malice if you can't give me a statement, because I can't even make the decision about whether
CRD is malice.
I know that I know your instinct is to say that. I know
it's not
that.
my instinct, it's my knowledge.
Well, check this out. So the whole theory that I constructed based on your arguments to me over like the last few months was essentially this. This was the way that we were going to cure that issue. We were going to make the argument, and I say we like I'm on the team, right? I think that the way you could have maybe gone about it, and the way that they were sort of kind of trying to go about it in their complaints, was to assert that Ryan Reynolds was an agent of Blake Lively. And although Lively wasn't making the statements herself, Ryan Reynolds sure as hell was. And when he called her and used that language, sexual predator, because you believe that they were in a fraudulent scheme together, or in effect were co-conspirators, then anything that Reynolds said should have been attributed to Blake Lively, making her just as liable for defamation as Ryan Reynolds. The shocking aspect of this case was not that they dismissed defamation against Blake Lively. It was that they dismissed it against Ryan Reynolds. That was the shock factor of the 12b6 decision.
Oh, I understand. I understood that part. I'm just trying to understand how lying in a CRD complaint without actually going further and proving, right?
Yeah.
So how was that decision made without her having to prove, right? So I'm just trying to understand. Forget about the 47.1. Forget about it. It's just general. Let's forget it's Blake. Let's just be it's X or A. I'm trying to understand how does it work. So I'm just going to give an example. I can go and file a CRD complaint, lie in it.
Yes.
And then I can go and spread that around and then sue. I have lied in it. The person knows and says that I have video proof of at least one statement where she has lied in the privileged whatever thing, the sexual harassment thing. How does one defend themselves against that?
Well, you could. This is how Baldoni's defense. This is how he's doing it. He's focusing solely on the defense. In other words, he's focusing solely on the veracity of her statements. He's not focusing on his own allegations against her. Now he shifted the focus to his defense against the claims. And his defense against the claims are essentially going to be in part that she lied about all of them.
What if she drops her case now? Let's say, I'm not talking about Blake. Let's say that person drops her case because apparently she's not obliged to go through with it.
Yeah, well, that would be dependent on whether or not Baldoni's going to allow her to drop her case without pursuing attorney fees and costs. Now, check this out. If she drops her case against Baldoni, she no longer has 47.1 treble damages, does she?
Okay.
And then Baldoni could go after her.
Can he do defamation still after?
No, that's been dismissed with prejudice.
But that's the whole. But I'm trying to understand the law. I'm sorry, but isn't that stupid and unfair?
I don't know if it's stupid or unfair.
No, because I
get what you're saying.
So sorry, how do you clear your name? Let's forget about Justin. How do you clear your name?
Proving that she lied.
Obviously, like I told you from the beginning, this was so premeditated, and she has this lawyer sharks, and they've thought about every loophole, obviously.
Right.
So Friedman better have something up his ass or sleeves. I don't know. He better be coming out or something. I'm still waiting. I've told him I'm giving him 2 more strikes. I'm still defending him,
Yeah.
but so there better be something else. But I'm just trying to understand. Let's forget about Lively and Justin Baldoni. How is this okay? Legal? How is this legal?
It's complicated. You're not going to like my answer. If I try to explain it to you, you're not going to understand.
No, please do explain. Please do
Okay.
explain. I want to understand,
So
but
listen.
don't like be like, oh, there's a rule this way. But how is that rule?
I don't know
okay?
how to explain it without telling you there's rules. I can't.
Okay, fine.
Because it's not going to
I'll
be
be
fair
quiet.
if I do it
Okay,
that
all
way.
right then. Okay, I'm listening.
Okay. Listen, like you said, forget about 47.1. All right? We're forgetting about it. The motion to dismiss was granted under 12b-6. 12b-6 is a federal rule that states that if you don't plead enough facts to state a claim, then your complaint will be dismissed. That has nothing to do with 47.1. And when Friedman failed to identify a single defamatory statement attributed to Blake Lively that wasn't in her CRD, which is privileged, he had to dismiss it. That was the legal basis for him dismissing it. And he denied it with prejudice.
But CRD is privileged because of 47.1, right?
No.
No, it's a
It is
legal
privileged on
document.
its own.
Privileged anyway, because it's litigation privilege. The part of 47.1 you're upset about is the treble damages part. That's the part that everybody's upset about.
I'm not.
Because in theory, there's nothing nefarious about 47.1. It's the fee shifting aspect of it that unfairly shifts a burden in a way that you feel like you could maybe weaponize 47.1. That's what everybody thinks is unconstitutional, including myself. But there's really good arguments to make that it's constitutional. I'm on the fence. I'm not on the fence with it. I think that it can be applied in an unconstitutional way. And on that basis, I think that it's unconstitutional. But let me get back to your question. How could she just lie? Okay, so look, 12b-6, it kicked out defamation, it's gone. That doesn't change the fact that Justin still has the ability to defend himself. So you said it before. How could you just lie in your well, you can't just lie. You can't just lie. If, for example, new evidence comes out that like smoking gun evidence that she 100% lies, she gets caught in a bold-faced lie on the stand, or the evidence is so compelling that she flat out lied in her CRD complaint, there's consequences to that. Could that become the subject of renewed causes of action? Maybe, potentially, yeah, can. You'd have to motion for an amendment against stuff based on new evidence, and there's a way to do it, but she's not off the hook. And plus, at that point, if there's a finding on that and it's based on new evidence that has not been pled, by the way, so we don't know what it would be. But if that happens, then she loses 47.1 protections. She loses treble damages, and she may be on the hook for Baldoni's attorney fees and costs, which are going to be substantially higher than $6 to $8 million where we're at right now in her defense of the defamation claim. So she's not just off the hook. She can't just dismiss all of this without some kind of consequence.
Yeah, but her consequence, it will be financial, but then Baldoni is left with this reputation damage because the CRD is like, the CRD itself is malicious, right? What's inside the CRD, just because it's protected. Like,
Yeah.
how do you go around proving without them? Let's say so far, we don't know what they've produced. Sorry, Leanne, I'm getting fired up again, but I'm just trying to understand, let's say, Omar, you are in this, imagine you're Justin Baldoni. How do you get out of it? Because you know for a fact, you have like evidence and everything. Mm-hmm. You have evidence as a defense, right?
Yes.
If the lawsuit goes, okay, let's put that, great. All of a sudden, sorry, I'm going to put Leanne, I'm going to make you lively, okay? Leanne goes, and then she drops her claims. She has a lot of money. She would rather pay you $20 million instead of going forward, right? Yeah. But then you are stuck with dismissed with prejudice defamation, protected whatever litigation CRD, like, and they haven't disclosed stuff for you in discovery that would prove the defamation. What the hell? You know what I mean? I'm trying to, like, isn't this supposed to be justice system? What happened?
I think what you want is for Blake Lively to go to jail.
No, not at all. I want her to say
Because
sorry.
that would be, I mean, if she broke the law somehow, that's not out of the realm of possibility. But if you're asking for whether or not Justin could recover for the causes of action that have already been dismissed with prejudice, no, he cannot. But can he bring up stuff if there's new evidence that comes to light that she lied about all this stuff? Potentially, yeah. Potentially. But we don't, the problem is I don't have that evidence yet. I don't know what that evidence would be. I mean, I know what his defense is going to be to some of these claims. I know that, but I don't have any knowledge of evidence that's going to point to that she maliciously lied. Because even if you think that her claims are ridiculous, if there's truth to the statement that, hey, somebody walked in my trailer and snuck a peek when I was pumping milk, even if that's ridiculous, it doesn't make it not true. And if she felt like it was stepping over boundaries, it makes her sensitive. It doesn't make her malicious.
No, they, like, Baldoni side, they said that she had a bodyguard like in front of the door, and that she had, anyway, I'm not going to get into those details. I'm just trying to understand, like, let's forget the details. Okay, got it. But, well, that sucks. Then you know what would be great?
What's that?
If Lyman has like a worker in his office who is very pro Baldoni, she should go and file a CRD complaint and do this to him, and then let him get out of this. That's what I'm thinking. Sorry, I'm like so pissed off about the dismissal.
You want Justin to file a CRD complaint about the no teeth thing?
Just like, just like be
he
like.
He could have. It's just that's not in his playbook, you know? It doesn't seem like.
No, I want somebody in Judge Lyman's office just to teach him a lesson. I would do that. Anyway, but I'm done. Thank you, Leanne.
I feel bad, Anita. I don't want you to leave angry. I don't want you to be angry.
No, I'm not.
I try to tell you, if I explain this the way that I have to explain it, you're not going to like it.
Oh no! Your insight has been great. It's okay. You're explaining to. I'm not angry at you. I'm angry at the law. So
you're not alone in that, for sure.
Okay.
Leanne, what was your questions?
Well, I didn't actually have any. I just wanted to come and join you and talk to you.
Just wanted to come on the show and.
I did, yeah. I've been trying to get on for like weeks.
Yeah, well, hell, I didn't even know.
Did Lauren not tell you?
Who's supposed to tell me?
Lauren.
She might have. But she says like a lot of people want to be on my show. She's like, hey, you got to go on with this person and that person. This person needs to be. And it's like, okay, well, I can't bring them all in.
I'm just better at
harassing. Yeah, thanks, Anita.
Yeah.
No, I love the show, so I was like, oh no, I got to go, because I just want to have a conversation, you know, and from the legal aspect, from the legal side of all of this, just kind of.
Yeah, I can understand why people are. I'm frustrated with this case as a lawyer. There's like stuff, like you want to get emotionally charged up about this case. Anita is very clearly charged up about this case. I've been emotionally charged up about this case. Everybody, there's like 519 people in here in the chat that are emotionally invested in this case. And the way that the laws are written don't make any sense. They don't.
No.
They don't. If I was not a lawyer and had to sit through 3 years of law school and passing the bar and 11 years of practice, it wouldn't make sense to me either. It just sounds like common sense that this case is bullshit and that there should be consequences and repercussions. I get it. I completely understand. Which brings me to my next point. Kassidy O'Connel. I had a really interesting conversation with her the other day. And the conversation that we had was stemming around 47.1. And she made some arguments that it should not apply to this case because it's not constitutional. It shouldn't apply because it's basically, they're trying to apply it like it's an anti-SLAPP lawsuit. And she just really nerded out. And I don't know what Kassidy's background is, I asked her that, but I don't think that she wanted to divulge, which is cool. I don't mind. For all I know, she could be like a law school professor. She could be like a law student. She could be an attorney for all I know. I don't know. Although I don't think she is. I think she's publicly stated that she's not. But she's clearly very bright and well-researched. And one of the issues that she took, well, she made a whole 1-hour video. And if you haven't seen it yet, I think it was titled to Blake Lively is cut off her nose to spite her face. And her theory behind the video was that Lively misapplied 47.1, essentially using it as an anti-slap statute. Anti-slap statutes have time-barred rules. If you're going to bring one of those, it has to be within 60 days. And she goes on about this whole thing. The first thing that she talks about was this argument about whether or not the law 47.1 was substantive, meaning that it will apply, meaning it should apply, or if it was procedural, meaning it was in conflict with the rules of federal procedure, federal rules, and it would not apply, such as like some of these anti-SLAPP statutes. The very easy answer to that question is 47.1 is not codified under the California Civil Rules of Procedure. It is purely substantive in nature, which means if we're abiding by California rule, it's going to apply. That was one argument that she had, which suggested that it would not apply. She stated that it functions like an anti-SLAPP statute. And it kind of sort of does. It kind of does. It certainly shares the purpose of an anti-SLAPP lawsuit, which is supposed to deter lawsuits that are against targeted communications. So 47.1 stands for this proposition that we should protect speech. They premise it on this idea that allegations of sexual misconduct should be privileged and not subject to attack based on defamation as a defense. And they don't outright deny it. They don't even qualify it that it has to be reach some measure of evidence threshold to apply. It just straight up says if you unsuccessfully assert defamation as a defense and you fail, treble damages. You're going to pay the plaintiff's attorney fees and cost times 3. That's what it does. It operates a little bit differently. The classic anti-SLAPP, it's supposed to provide a special motion to strike. So the simplest way I could say is when you assert an anti-SLAPP motion, like Kassidy was talking about, that has inherent in the language of it, and I don't know how many, there's like 38 states that have these kinds of, I forget the number. I think Kassidy had mentioned it in her video, but when you assert an anti-SLAPP motion, it's a special motion to strike, separate from Rule 12b6 or a Rule 12 motion to strike. 47.1 has no such mechanism. It's not a motion to strike at all. Matter of fact, when Judge Lyman made his ruling to dismiss, it was purely based on Rule 12 and had no consideration whatsoever to Rule 47.1. None. He declined to rule on whether or not he would apply treble damages pursuant to 47.1, but he invited them to bring a motion seeking those sanctions, and he would rule on that at a future date. But 47.1 legally and structurally had no relation whatsoever in Judge Lyman's ruling to dismiss at all. Are you guys with me? Or am I getting too dorky? Okay. If I'm not making sense, just let me know. That's the distinction. And the reason why that's significant is if we were to treat this like an anti-SLAPP statute, we're in the Second Circuit. In the Second Circuit, there's this case, I think that, I forget what was it called, Liberty or something like that.
Yeah.
That Kassidy had mentioned. The Second Circuit is not kind to anti-SLAPP statutes. In other words, it conflicts with federal law. They generally don't survive. But in this case, this not being an anti-SLAPP statute, this not being a motion to strike based on 47.1, when Judge Lyman granted the 12B6 motion, it had nothing to do with 47.1. And the substantive rights inherent in Rule 47.1 would apply because it's a substantive right that is granted by that statute to Californians, and both parties already suggested that we're going to go by California law when it comes to these causes of action. Therefore, 47.1 will apply and cannot be stricken down as an anti-SLAPP because it's substantive law and not procedural in the same way that anti-SLAPP statutes are procedural. Does that make sense?
Yeah, it does.
Okay. Whether or not it's constitutional or not is a much more difficult question. And I will suggest to you that I can make an argument and I will go in front of the steps of the Supreme Court and I will argue for hours that it's not constitutional because it violates due process rights of litigants that have legitimate claims of defamation and chills their rights to access to the courts because of the invocation of treble damages should they lose their claim. I can do that. The problem with that is I would not be a part of a specially protected class of individuals that would subject 47.1 to strict scrutiny. What's much more likely to happen is this is going to become a question where I'm not protected, and the Supreme Court will look at this under the rational basis test. In other words, is there a rational basis that this law exists? And you can make an argument. Yeah, of course. 47.1 is meant to protect privileged speech against unfair attacks for defamation, whereby people more economically sound will attack through litigation their accusers. And then you'd hear that and you say, oh, that's rational. There was all these arguments while they were codifying the law, where they were legislating it back in 2023 that Kassidy had on her video where they're making all these arguments. That's basically their rational basis for applying it. And if you look at a case like Tyler Perry versus Dixon, 47.1 makes so much more sense in that case than it does this one. In that case, Tyler Perry has a net worth of $1.5 billion. His accuser, this actor, was maybe making a couple $100,000, $300,000 when he could get to work while he was an actor on Tyler Perry's television show. The disparity in income could not be any greater. And so to the extent that Tyler Perry was going to sue him to the gills with defamation claims, 47.1 protects against that kind of conduct. And that would be, if I just gave you that example, ignoring Baldoni and Lively, that would be the rational basis behind 47.1, and where the Supreme Court might say, yeah, I mean, that makes sense. And they might deem it constitutional on that basis. What you're not examining is, they would examine it in an argument, but in this case, we have Blake Lively and Justin Baldoni. What's the disparity in income there? I have no idea, honestly. I don't know what their net worths are respective to each other. I've heard rumors that Sarowitz is funding the litigation. I'm sure that Blake Lively has plenty of money to defend her own, pay for her own attorney fees or cost or whatever. But she has all of these resources and she's taken advantage of 47.1 in a way that was contemplated to apply to somebody much less well off than her. That is the constitutional rationale for 47.1.
And sorry, Leanne, go ahead.
No, sorry, I was just going to say, that's exactly what I actually said as well, is, I can, coming at this from, someone, from a lawyer myself, and also from someone who's kind of been on that end of, being in an abusive marriage, I can see the rationale and what they're trying to achieve with 47.1. I feel like especially from the resources side, as you said, but the one person who did not need those resources was Blake Lively. And I think in all those amicus briefs, the last one, I can't remember where that came from, where there was like 18 of them all putting in, their bit into one amicus brief. There was it was hidden in a footnote, but even they agreed that, Blake Lively was unlikely to be the intended, beneficiary of Rule 47.1.
Yeah.
What do you think when Judge Lyman says, I invite you to file for the treble damages and I will rule on this later? Do you think he means at the end of the trial, where she's the plaintiff and Baldoni, Wayfarer are the defendants? Because obviously there is a good faith part, an element to 47.1. So would he, if he's going to apply 47.1, would he not see how her actual claims for sexual harassment and his defenses stack up with that? Do you think that's what he means when he says he ruled later?
No. Well, the problem with it is Judge Lyman ruled that he didn't find malice properly pled in Baldoni's complaints. That doesn't mean that he might not find malice at trial, the way the case is presented. She's only protected by 47.1 if malice is not demonstrated in her case. In other words, if it's a good faith claim, then she would be protected under 47.1. If it's found not to be a good faith claim, then she is not.
Yeah.
And because this law is so brand new, I have no idea how it's supposed to be applied. I mean, I would think it reasonable because, look, it's not going to be the case. Okay, if you're going to say you don't want defamation defense against sexual harassment claims, then you have to allow for defendants to defend themselves without bringing that counterclaim and still being able to present evidence of malice at the time of their defense. And if it could be proven at trial that her claims were malicious, I think it almost imposed holding off on 47.1 damages until the conclusion of trial.
Yeah, that's what I said. Man.
Yeah.
Yeah. That's what I would hope that he would do that, because otherwise, you're not testing that good faith requirement of 47.1 if you kind of throwing out the defamation claim, which I don't disagree with. I didn't think it was a strong claim. I understand why they did it, but but I do think, well, if you're going to apply the treble damages at this point, that's an issue. That's a big problem. But if you get to the end of her side of the lawsuit, where she's actually pursuing the sexual harassment and retaliation claims, and he is defending it, and you see all the evidence, then at that point is it's really the only point you can really assess whether she has raised the concerns about sexual harassment in good faith.
It's going to be fascinating how the judge handles this motion, because if he decides, I just don't see how he can make a ruling that there was no malice just because he dismissed Baldoni's claim. I think in order to apply 47.1 in good faith, you have to test the merits of her case at trial.
Yeah.
I think you have to, if you're going to impose. I feel like that's the wiggle room in 47.1. Like, you don't have to assess treble damages right now. It'd be kind of absurd to do that without making her prove her case.
Exactly. That's my logic is, if he applies treble damages at this early point now without doing that, then I've got a real problem with that. I think that does raise legitimate questions there, and I would hope that they would consider some kind of appeal over that as well, because I can't imagine that 47.1 was intended for that.
Yeah, no, I mean, it's funny. You make these laws and you don't intend them to have absurd results, but sometimes they do. And so how this is applied, I'm hoping that upon motion for treble damages, it's delayed until conclusion of trial. Because it would force her to, at the very least, or you're going to get your treble damages, but only upon a finding that your complaint was brought on good faith, and make her present all the evidence. And, what's funny is I think that even if she goes to trial, she has just enough evidence to prove against malice, just because, the absurdity of her claims, but if she herself believed that was crossing a line just subjectively, that doesn't itself form malice. Like malice in California, it's a reckless disregard for the truth. In other words, they got to prove that she lied in order to do it. And maybe they could do that. Maybe they can. I think that they may be able to, based on some things that we have, like, for example, the video stuff. There were some other things that Anita was alluding to. I hope Anita didn't just like storm off because she's like so frustrated with the stuff that we're talking about.
No, I'm here. I'm listening to legal commentary.
I'm trying to give Anita hope that there's still hope. There's still hope. Like, this isn't over. It feels shitty because of how it's gone, but it's not over. I got to get to some of these comments. Joe Bad says, what's going to happen when James Vituska retracts his sworn affidavit? I don't know yet, Joe. I don't even know what that affidavit said. I don't know how it impacts the case.
It basically said that no, I misspoke when I said Leslie Sloan accused Justin Baldoni of sexual assault. I meant sexual harassment. It was something like that. He basically did a declaration saying that's not what I meant. And now the what the rumors are, I haven't seen anything to kind of 100% verify it, but the rumors are that he's going to retract the statement and claim that he was made to do it under duress. I didn't think it was. I don't think it's going to make too much difference though, because Sloan wasn't dismissed because of the declaration.
If that's the only thing that's getting retracted, or the strength of what's getting retracted, I don't see how that really applies to much in this case. I don't think it's going to affect anything.
No,
at least on the lively Baldoni side of it. I don't know, but I guess that would be my answer to that. Thank you for telling me I was muted, Riley. I spoke for like 3 minutes without knowing I was muted. I haven't done that in a long time. Anoli Eustace says, if they had nothing to do with anything and are irrelevant, then why subpoena someone you don't have anything to with phone records? I don't follow. Then why subpoena someone you don't have anything to do with phone records? Leanne, could you make sense of this question? Am I reading it wrong? What are we talking about here?
Well, I mean, I know they've subpoenaed Brian Friedman's phone records.
If they had nothing to do with anything and are irrelevant, then why subpoena someone you don't have anything to do with phone records? No, I'm sorry. I can't.
Leanne, was it you who said that you think they subpoenaed because they wanted to see on February, like they're so adamant the smear campaign is ongoing now, to see if who from Taylor's side called them, because they would have the numbers of the
so Friedman, obviously, when he put out his affidavit, he gave kind of said, well, on February 14th, I had this conversation. I was, left a voicemail and I called them back. And then, I've had several other conversations regarding all the stuff with Taylor Swift. And Lively has now subpoenaed Friedman's firm, and part of that request includes Friedman's mobile phone records, but she doesn't want anything that identifies anyone. She just wants the phone numbers, the dates, the times, and the duration. And the only thing I can think, unless she's going to ring all of those numbers and say, who are you, is to see if she recognizes any numbers, because she's obviously going to know, probably going to know the phone numbers of people close to Taylor Swift who may have called on those specific dates. It's just a theory, but I mean, I find that quite a. I have never heard of that actually, really. To ask for that kind of request from the opposing counsel.
To answer this question, they were talking about Van Zandt. Why would they subpoena someone's phone records that they don't have anything to do with? CMAX says they're talking about Abel's phone records. The question is, why would Van Zandt need either Steph Jones or Abel's? They have no business or contract with either.
Yeah. So this makes sense now. So yeah, what they're saying is, well, so the subpoena was described. The description of the subpoena, what it was looking for, was specifically the data that was extracted from the mobile phone, which has information about Lively and Reynolds and Justin Baldoni. It's very, very specific for a Doe lawsuit, basically. I think that's why what everyone means is, why would you subpoena go to? Because they're trying to say, Van Zandt is trying to say, well, we've got nothing to do with this employment dispute. But then they went to the employer and said, by the way, can we have, the data from your former employee's phone?
Right.
So how can you argue? And I just to clarify, because I was kind of when I was backstage, like you were reading the letter, or something I just wanted to sort of clarify as well to give context. In the letter, Van Zandt it gives the impression that they have supplied a copy of the subpoena and the information that will come with it. They haven't. Lively has as an individual party, but Van Zandt is obviously, it's still Lively, but it's her business.
Right. There's tie into it, and then I think some of the other theories that they already had all this stuff. They may have obtained it illegally, and so they're laundering it.
I think the requests are, so Jen Abel has subpoenaed. She's got the information. She's got the subpoena and the information that went with it from Blake Lively, but she also wants it from Van Zandt. She wants it from Stephanie Jones. I don't think that's entirely unreasonable when you believe that the subpoena was just a cure for information that had already been shared.
Yeah, not at all. Yeah, that's the point that I was making earlier. Shinonos, thank you so much for the 10. She says, they said Van Zandt is irrelevant to the Jen Abel and Steph Jones situation, so why was Van Zandt able to subpoena with the Doe lawsuit? Jones works for Jen Abel's phone. Well, they could have objected to it. The problem with that is nobody was notified. The point of the Doe lawsuit is you don't have to notify anybody of its existence other than the person you're handing the subpoena to. And if she doesn't object to it or think to give it to her attorneys, then, well.
Oh no, what they're trying to make a point is just like, oh, they're being ironic. Just like, well, if it's irrelevant to their case, why did they subpoena Stephanie Jones? Like, how they wrote the letter. So the hypocrisy.
Like Bruce said, I'm a literal reader. Sometimes, no, you're right. That's a great point. Exactly. Well, you all subpoenaed it, so we want to know what you were subpoenaing it for. It was important to you then. So why is it relevant now?
That could have some of that data for, we don't know, but some of the data, obviously, it's alleged that Stephanie Jones had access to Jen Abel's personal data as well as the stuff for the work.
Yeah.
So as I think that's such a ridiculous argument. I think she's, it's fair game for her to ask for it.
Well, if they did get access to her personal information, there's possible wiretapping implications, federal crime, other stuff. There's things that they could look into that I don't have time to get into now because I'm supposed to start Family Law After Dark in about a minute. And Leanne, I'd invite you to come on to that show, but I know it's really late for you. And so I don't do that to you.
Thank you for the invite. I will probably hop out now. But I've really enjoyed this. I'm so glad to finally get on here.
Yeah, thanks for coming on. We got to do this again sometime.
I'd love to. I
really enjoyed your insights talking to you about this.
No, it's nice to have that kind of a bit of a legal powwow.
Yeah,
so
sometimes
I enjoy
you just
that.
got to nerd out.
Okay, well, I'll dip out. Thank you so much, both. And Anita, I'll speak to you again soon as well.
Yes.
Speak
to you soon. Good night.
You take care. Anita, you're coming on a Flad?
Yes, I am.
All right, we're going to get started in about 3 minutes, folks. I'll see you guys over there. I love you all. Bye-bye.